breakfast. We appreciate that. And we've got some good bills for consideration this morning. The first one for consideration is Senate File 167, Domestic Violence Protection Hearings, Remote Appearance, sponsored by Senator Nethercott and others. Senator, good morning. Walk us through what Senate File 167 does.
Good morning, Mr. Chairman. Good morning to you, Senate Judiciary Committee. Good to be back with you. Good senators, what this bill does is it just places in statute that at the time of filing a petition for a protection order, and a protection order is the petition alleging that an act of domestic violence has occurred. It is a civil remedy and a civil process that the applicant, the petitioner, can request that court hearing allow one of the parties to appear remotely. It also allows for the respondent, which is the person who is the recipient of a petition for a protection order, to elect to appear remotely as well. And as we know from the last couple of years, our courts are equipped with the appropriate technology, allowing for remote hearings. And so they currently have the ability to do this, but I've been approached by a number of interested parties to really just expressly authorize this in statute, primarily due to the wisdom of not having the two individuals involved in the petition for protection order needing to come together at the same time in the courthouse in the same room when there has been an allegation of domestic violence. And again, it's a civil process, and so the respondent is not in the custody of law enforcement, most often is not in the custody of law enforcement. And so this kind of provides some pragmatic, practical protections associated with what is sometimes a dangerous situation. And so the bill is on page 2, lines 1 through 8. It's pretty explanatory, allowing for that remote appearance. I'm happy to stand for questions.
Senator, thank you. Always good to have you back in Judiciary. Senators, questions? Senator Schuler.
Thank you, Mr. Chairman. I think this is a really good bill. When I was reading through it, I only had one question, and I have no idea if this would ever even happen, but what if both of them petitioned to do a remote hearing, and does the court just take the first one, or the person that has the victim, or I mean, how does that work?
Senator, go ahead.
Mr. Chairman, I think the court would likely grant both of their requests and have both the parties appear remotely. Of course, during the pandemic, that's how that was conducted, because no one was coming into the courtroom. Courtrooms are a little bit different, I should say, where it is beneficial to have the parties who will be testifying live, because it is a fundamental duty of the court to evaluate the credibility of the witnesses. And so it's, of course, as we all know, that is far easier to do and to weigh when someone is in front of you. So a heavy burden for the court to consider and evaluate, and I trust the court's discretion that if they feel they are unable to make a determination on that remote appearance, that they can make alternative arrangements requiring one of the parties to appear in person. The court's not required to authorize the request, but just essentially instructs the court that this is probably a preferred method of conducting these proceedings in today's landscape.
Senator, I appreciate you touching on that piece of it, as well as the, keeping parties separated, I think is one of the real values of this bill. But the piece that you just alluded to, when it is a little tougher for the judge, I would assume, to be able to discern certain things. You got to do that over a screen instead of this way. You've been in the courtroom before. Are you confident that we're okay?
I am, Mr. Chairman.
Further questions? Senator Murphy.
Thank you, Mr. Chairman. Senator Nethercott, do almost all of these courts have the facilities to do this remotely? Thank you.
Mr. Chairman, they do.
Senator, what courts, where do these normally end up? It's circuit court, right?
That is correct, circuit courts.
And yeah, and I think we have caught up pretty well out there, so that's good news. Senator, thank you. We may come back to you with a question a little bit later.
Mr. Chairman, if I may, the technology that the court uses for most of these appearances is like Microsoft Teams. Right, so just like how we appeared on Zoom for our legislative meetings during the pandemic, Microsoft Teams is a similar platform to Zoom, and that is exactly what the court uses. So the parties are wherever they may be on their laptops or phones. And if the parties don't have ability to do that, right, the court can have them come in. It's not a requirement, but it is that easy.
Yeah. Good job, Senator. Thank you very much. Let's go to some testimony on this little Senate file. Is there anyone who would like to testify on Senate File 167? Please come forward. Welcome and good morning. Please state your name for the record for us.
Morning, Mr. Chairman. My name is Beth Lance. I'm here today on behalf of the Wyoming Trial Lawyers Association. We stand in support of this bill. I would agree with Senator Nethercott's comments regarding the availability of this technology already, the ease in which attorneys and their clients now are utilizing this, since we did do this for nearly a full year, is certainly there. Courts are familiar as well now. And I think in particular, these kinds of civil proceedings in which the parties obviously have animosity or potentially threats made between one to the other party, it can be quite stressful for parties to have to face each other in these hearings. There can be fallout from people following people away from courthouses, continued stalking issues, things like that, because that may be what they're there for in the first place, is harassment and stalking, depending on the case. And so this seems like a very good way in which to hopefully help encourage people to seek the court's assistance when these kinds of things are occurring. Additionally, the protections are in this legislation, which allow for it to be objected to. So if one party is petitioning the court to appear remotely and the other party would have good grounds to object to that, to require in-person appearance, they can certainly then respond to that to the court, make that known, explain what their grounds are for requesting everyone being there in person, and then the court can make a determination. So because that protection is there, our association is in support of this bill.
Lance, thank you very much. Good points made. It strikes me that this would allow, unfortunately, in situations like this, sometimes one of the parties needs to be out of town. I mean, literally go stay with a parent or a member of the family might be out of town. That it strikes me that this would allow for a savings of having to travel back or to, bring an attorney from out of town somewhere, and maybe it could even be a cost saver. So,
yes, Mr. Chairman, your point is well made. Those kinds of events often occur when these kinds of incidents are happening. So,
questions for Ms. Lance? Senator Schuler.
Thank you, Mr. Chairman. Just a follow-up to what you mentioned about the potential for someone to deny that. What would some of the reasons be for that, just out of curiosity?
Ms. Lance?
Mr. Chairman, Senator Scholler, certainly, as I believe Senator Nethercott started to explain, we have a right to confront witnesses, and there could be a reason that confrontation should be in person and not remote, and that it's important that those people be able to confront them in person in the courtroom. Maybe there's concerns. I've unfortunately had cases where there have been concerns that maybe the other party is so dishonest that you can't trust that someone's not feeding them answers, those kinds of things. And so if you have some basis, obviously you would have to be able to explain what that basis is. But if you had some basis that there was true concerns for it being a fair hearing or for there being true confrontation of that witness, you would be able to at least provide that information to the court.
Thank you. Anything else, committee? Thank you, Ms. Lance.
Thank
Appreciate
you.
it very much. Further testimony on Senate File 167? Let's come forward. Good morning. Yeah. Tara squared at the front
That's
table there.
right.
There we go. Good morning.
Good morning,
Yours?
Chairman, committee members.
Please.
Great. I'm Tara Muir, Public Policy Director with the Domestic Violence Coalition here in Wyoming. We have programs across the state, every county. Our advocates are not lawyers. They're community-based advocates. The whole protection order process is pro se. So several of them have come to me and clearly have come to the senator to request this relief in some of these really stressful cases. And we support it 100%. Happy to take any questions.
I'm sure we touched on several of the issues that your advocates and volunteers have run into out across. Need to keep people separated, safety issues regarding the stalking piece and all of that. So appreciate you being here.
Thank you,
Ms. Muir.
Chairman.
Thank you. Any questions for Ms. Muir this morning? Thank you. Further testimony on Senate File 167.
I think there's someone on Zoom, perhaps.
Okay, we're going to go to them here in a second. Anybody else in the room want to testify on 167? Okay, Judy, if we have someone online, we'd sure welcome them.
If the person online wants to testify, she just went offline. Oh, is she joining?
Good morning. Please unmute and state your name for the record.
Good morning. My name is Jeannie Gore, and I am an attorney here in Laramie. I have a long history of working with survivors of domestic violence, sexual assault, and stalking in protection orders. First as an advocate, and then I was a staff attorney for the Wyoming Coalition Against Domestic Violence and Sexual Assault for a number of years. I now serve survivors in private practice. I think there are three main reasons that this committee should consider this bill. First is, some of them have been touched on a little. The first is subject matter jurisdiction. What that means in a non-lawyery way is that these matters have to be heard in the place where they happened. The court cannot waive that. Frequently, people flee after an incident like this. A victim of sexual assault leaves college and returns home to her parents. A mother with young children goes and stays with her sister out of state. And it is burdensome to return back to the scene, essentially the scene where it happened. It creates a financial burden. It can create very significant logistical burdens for someone to return back. And the court has no choice in that. Subject matter jurisdiction cannot be waived. It has to be heard in the court where the event occurred. The second reason, which has also been touched on a little bit, is about trauma. It is very scary and traumatic to appear in a protection order hearing. The vast majority of people are appearing without counsel. In some courts, they'll allow an advocate to sit at the table with a survivor, but in some courts they don't. And so here is this survivor sitting at the table mere feet away from their perpetrator, talking about some of the most personal and traumatic things that have ever happened to them. That is really difficult and scary. One of the things we learned in COVID is that remote is possible. It's not perfect, but we figured out that in most cases, it's good enough. And there are really good reasons that it can be a great tool. An example that I thought of is I represented a 15-year-old girl in Sweetwater County in a in a stalking protection order hearing. And she was able to testify in her living room, sitting next to her mom, rather than in the courtroom against this grown man who had been stalking her for a number of years. How much that impacted her ability to have the courage and strength to be able to go through with the process. I represented another woman who was a victim of sexual assault and was able to testify in the domestic violence advocacy program office rather than sitting next to her perpetrator. The last reason was also testified to, and that is the threat of violence. We know that one of the most risky things a person who is experiencing domestic violence can do is to try to end the relationship. Filing a protection order can be very risky for safety reasons. And having to be in the courtroom where your perpetrator knows you're going to be there and can plan ahead of what they're going to say or do when you arrive can be a really risky thing. I represented a person in Laramie County whose perpetrator, as we are walking out of the courtroom, threatened her under his breath. Fortunately for her, the bailiff heard the threat and he was able to be charged. Another time I represented a survivor in Albany County, and as we walked out of the courtroom, her perpetrator was standing next to her car. And police were called and he was arrested. But there are so many times when these kind of threats happen that are not so overt. A survivor knows what a look means, or a word, or something so simple that maybe other people in the courtroom aren't going to pick up, but that survivor knows very, very well that that's a threat and that they are that there's a possibility of harm. So I would ask that the Senate Judiciary Committee move forward this bill. I think it's a wonderful tool, and it protects everyone's rights and most importantly, protects everyone's safety. Thank you for allowing me to testify. I'm happy to answer questions.
Ms. Clark, thank you. Really admire the work you do. Thank you for that, and thank you for your testimony. Committee, any questions for Ms. Clark this morning? Thank you, Ms. Clark. Have a great day. Thank you for being here this morning. Is there anyone else online, Judy, who would like to testify? Okay, I'm going to close public testimony. Committee, what's your pleasure on this bill? Moved by Senator Schuler. Discussion. Are you ready for the question on the bill? Any amendments? Question? Judy, please take roll on Senate File 167.
Senator Case?
Aye.
Senator Cooper?
Aye.
Senator Murphy?
Aye.
Senator Schuler?
Aye.
Chairman Landon?
Aye.
Mr. Chairman, there were 5 ayes on Senate File 167.
Senate File 167 has passed the Judiciary Committee. Senator, thank you for joining us this morning. It's a good little bill and we'll support you up on the floor. Okay, committee, I'm going to ask if Vice Chairman might take over the mic on this one. This next little bill, I'm going to change the order a little bit, and we'll take up the governor's background check bill, and then Senator Barlow will join us in a few minutes to return to the civil rights bill in a little bit. Okay. So take it away, Mr. Vice Chairman.
Thank you, Mr. Chairman. So our next bill for consideration is Senate File 129, background checks the governor's office. And to present that bill to us this morning is the good chairman of the Judiciary, Senator Landon.
Well, Mr. Vice Chairman, thank you. And I'd ask Betsy if she'd be willing to just come up. I'm not going to come out front, committee. I think it hopefully won't take very long to explain the bill, and Ms. Anderson can help us even further on that front. So from the 30,000-foot view, committee, this is a bill that came from a conversation that our deputy chief and I had early in the session, and it was my opinion that we could get this up and out and considered and maybe assist the governor's office on this front. And what the bill does essentially is that it would allow the governor to execute or request background checks for those who would go to work in the executive branch in his office. This was something that took place in the past, but our federal partners indicated 4 or 5 years ago that they just couldn't do that anymore because after an audit, they discovered that we really don't have, we have not given the governor the permission in statute to do it. And that's the 30,000-foot view. So, Mr. Vice Chairman, I think Ms. Anderson might be able to present even more of a background that might be helpful.
Thank you, Mr. Chairman. Ms. Anderson, will you state your name and tell us what you have to say, please?
Good morning, Mr. Vice Chairman, members of the committee. My name is Betsy Anderson. I'm the Deputy Chief of Staff and General Counsel for Governor Gordon. And I want to thank you for considering this piece of legislation. As Chairman Landon has mentioned, the governor's office does not currently have the ability to conduct background checks on its staff. I think people would be surprised to find that that's the case. But as he mentioned, for the federal check, it has to be in statute. And so we're bringing this forward, and I'm happy to walk through the bill. It's very short. I would walk through it maybe backwards in that it amends 3 statutes. And the first statute, logically for me, is on page 2, section starts on line 7, and that's 719-201. And that is the section that lists numerous agencies and state employees, departments that have the ability to get fingerprinting in order to conduct a background check. That is then submitted to DCI, and then DCI works with the FBI to conduct the background check. So we have added the governor's office. You can see that is the 30, that's 40. That's a Romanet 40, I believe, 39, maybe 34. So this would then, even if this legislation is passed, the FBI then still has to look at this and approve that they will then conduct those background checks. To go to the prior statute that's being revised, it starts on page 1, line 11, 719-106. That is the list of agencies and departments that have the right to the information from the background check. So if you're not on this list, they can conduct the background check, but you can't receive the information from the background check. So you need to make sure that we are also, and that's the one where we're listed number 40, as criminal history record information shall be disseminated by the criminal justice agencies to the following. And so then the governor would be on that list. And then the third statute that is revised is on page 2, starts on line 20 and carries over to page 3. And that's just 91201 that lists the general duties and authority of the governor. And a general statement is included in that particular statute that indicates the governor's office has the authority to conduct the background checks. The reason the governor would like this ability is we do consider and deal with a lot of security issues. Obviously, just the governor personally and the residents, but we work with Highway Patrol in a lot of various security situations. We have dignitaries, we have other state governors, we have federal dignitaries, we have international dignitaries that visit our office. There are security issues involved with that. And then, of course, we work with all the various agencies that have confidential information, Homeland Security, military, corrections, and that. And so that would be the reason why the governor's office would appreciate having this ability. And I'm able to answer will try my best to answer any questions.
Mr. Vice Chairman, just real quickly, I did provide a little sheet that separates out the statutes that are affected I hope that's helpful. Also some notes that I provided to the committee. So, and that was with the help of Ms. Anderson. So appreciate the Governor's Council helping us on this. That's the bill, Mr. Vice Chairman, and I sure appreciate Ms. Anderson being here.
Thank you, Ms. Anderson. Committee, any questions for Ms. Anderson? Senator Schuler.
Thank you, Mr. Vice Chairman. The only question I had is, I had wondered in the past if you'd had issues when hiring folks, not being able to access their criminal backgrounds, if you had some folks, and just since the governor's been in office, that this would have been a great thing to have.
Mr. Vice Chairman, Senator Schuler, I can only speak to the Governor Gordon's administration, and I cannot speak to personnel matters, but I will say there has been a situation where and whether it would have made a difference or not, I don't know, but it is something that made us sit back and think again. I mean, we always realized we weren't doing this. We did realize it had been done before, but a particular situation did give us concern.
You know, Mr. Vice Chairman, I just thought of a little different angle, thanks to the senator. You know, as you mentioned, Ms. Anderson, it may not have made a difference in a hiring, for example, but I think it's good for any manager to know what they need to know about who's working in a department, including the executive office of the state of Wyoming. Just might be something in the background there that the governor might need to be aware of. Isn't that right? So.
Yeah. Mr. Vice Chairman, Mr. Chairman, yes. And I will go on and say, we are a small state, and I feel like Governor Gordon knows everybody. So it is at the governor's discretion that we would conduct this. So I'm not saying we're going to run out and do a bunch of background checks, but certainly we got worlds. We know we're looking at things, especially when you look. We've talked about digital currency and these things that now we're bringing in people from across the country and people that we don't know on a personal basis. And so that's another reason why, as Wyoming kind of expands in some of these areas, that would be nice to have, and other agencies, as you admit.
Yeah, good point.
Thank you. Thank you, Ms. Anderson. If there's no more questions, we'll ask you to kind of hang close for a few minutes in case we have I'm sorry, Senator Murphy.
Thank you, Mr. Chairman. Let me ask about, if I'm reading this correct, it's only to check for criminal records. Mr. Chairman, what I'm curious about is, can you check employment history? For example, if they have been employed and they've committed some acts which aren't necessarily criminal, but they've disseminated information or been fired from a position previously, can you access that information? Thank you, Mr. Chairman.
Ms. Anderson.
Mr. Vice Chairman, Senator Murphy, I think the best you can do in that situation is call their references and check their prior employment. But I will say most prior employers, they're not, if there's not been a criminal conviction, they are not going to say anything. They will confirm dates of employment. So that is something that would not come forward in this check. I will say when we hire people, certainly we call their references, but if we know people that they know that's not a reference, that is an even better reference, right? Because obviously, who's going to give you a reference that's not going to give you a name is not a good reference. But yeah, so that's for our office. It's like, oh, we know they know Susie Q. We're calling Susie Q even though she's not been provided to us as a name.
Thank you, Ms. Anderson. Any further questions for Ms. Anderson? All right, Ms. Anderson, we'll ask you to kind of hang close for a few minutes. Further testimony in the room? Senator Barlow, were you wanting to speak to this? But welcome to our Judiciary Committee. Good to see you here. Judy, is there anybody online that'd like to speak to us?
There's someone online, but no hand up.
I'm sorry?
No hand up.
next bill, I think.
Okay, nobody there. So committee, what's your wishes on this bill? Move the bill. So any further discussion on the bill? We want to take a quick look at it. Page 1 is pretty straight up. Page 2 is where the heart of the bill is. Thoughts, amendments on page 2?
Mr. Vice Chairman, I think well drafted. I think it's maybe ready to go. I don't have anything, so.
Okay. Page 3, anybody? All right, no further comments on the bill. Judy, would you like to take roll, please?
Senator Case.
We'll hold that vote open for him.
Senator Cooper.
Aye.
Senator Furphy.
Aye.
Senator Schuler. Aye. Chairman Landon.
Aye.
Mr. Vice Chairman, there are 4 ayes, and we're holding over Senator Case's vote.
Okay, thank you, Judy. So Senate file number 129, background check for the governor's office is that's the committee here. We're ready to move on.
Okay, thank you. Thank you very much, Senator. Appreciate you taking over. We're going to turn now, committee, back to Senate File 120, Restoration of Civil Rights. You'll remember that a couple of days ago, we took some testimony and began work on the bill. We ran out of time. And welcome back, Senator Barlow. Good to have you back on a bill that we look forward to working with you this morning on. So please come on up and help me to remember kind of where we were. That's the deal. So, and I want to make sure we get back to any other public testimony on the bill that we need. So.
Thank you. Good morning, members of the committee, Mr. Chairman. Appreciate the opportunity to continue this discussion. I think where we were last time is we had heard from the Department of Corrections. I mean, I had kind of presented the overview of the bill, not in great detail because of the time constraints we were under, but overview of the bill, we heard from Department of Corrections, and then we heard from a member of our community who had lost a daughter, if you recall, and was very concerned about some of the challenges we have, particularly on the domestic violence portion. And then Ms. Muir was up and did not provide, I'm sure, the completeness of her testimony, but at least opened the door to their interests and their concerns. Since that time, Mr. Chairman, I want other folks to come forward. Since that time, I continue to learn. We all continue to learn as we get feedback and engaging with our colleagues and with folks in the community. So there are some things that I think, as I said when I introduced the bill, this bill has really 2 big pieces. It has a felony component, nonviolent felony component, restoration of rights, and then it has the misdemeanor domestic violence component. And I've received a nice piece of work of research. Kudos to our legislative intern program that provided a nice piece. And I literally just got it last night, so I haven't even reviewed it completely, but I took some of the highlights. And some of the highlights are that there are very few states in the research, and I think there's 12 states listed that have tackled the DV thing, domestic violence, because of the federal nexus, because of the challenge of the federal nexus. Many states, many of our neighboring states, many states in the country have either automatic or a time period for restoration of other civil rights, including firearm rights. So that road is traveled. The other one is more challenging.
Senator, sorry to interrupt, but can we go back to the federal nexus for just a moment? Can you remind / educate the committee on that goes to the fact that if convicted of certain domestic violence things, you can have your firearms taken away for a lifetime, right? What's the federal nexus? Tell us.
Mr. Chairman, actually, the federal nexus for the state of Wyoming is for both felons and domestic violent misdemeanors. There is no, the state of Wyoming does not take away firearm rights for either category, but the federal government does. Federal legislation does. The felon one is much older. I can get the citation, much older. The domestic violence one is more recent, but they are a prohibition on the use and possession of firearms. And when you get into the domestic violence one, it goes further. It goes to purchase, et cetera, et cetera. It goes further down that road. And so the nexus is there is a way, and there's court precedent for restoring felons' rights. If you restore all of their civil rights, their firearms rights are part and parcel to that. And you can't actually just give them their gun rights and not give them the rest of their civil rights. There's actually, you have to, I'm not going to say it's all or nothing, but at least the way the 10th Circuit, my understanding of the 10th Circuit is, if you're not doing a complete restoration, that's why an expungement in and of itself doesn't work, because an expungement is just hiding the record. It's just saying, well, but the reason expungement doesn't work, because if there's a subsequent crime, the expungement can actually become part of the record and say, no, this is your second time or your third time if it's one of those crimes. So the nexus is for all crimes, I shouldn't say all crimes, federal felonies and domestic violence. The difference is the domestic violence has so many more complexity, at least in my view, so many more complexities just in definitions of the crime. Let's be clear, there isn't even a domestic abuse crime. It is a myriad of crimes where someone is assault, battery, endangerment. Mr. Chairman, you talked about strangulation of a household member. So it starts to get into a myriad of other issues. The other thing, and this is a more practical matter, is we presented the bill the other day, and I presented the bill, and then we heard from the Department of Corrections, is I incorrectly assumed that the Department of Corrections was the appropriate place for this to be done. Now receiving the numbers, and I can be more precise with numbers, they have a couple hundred of these misdemeanor domestic violence under their supervision. The rest, 600 plus, are under individual courts of conviction. So now we're bringing in another branch of government, which is appropriate if we're going to go down this road, but then we have another branch of government which I have not conferred with in this process. And so, Mr. Chairman, I don't like giving up, but I also know where there's limitations and where the complexities of the issues just become, there's more to learn. We cannot get it incorrect. Cannot get it incorrect as a matter of policy, and we cannot get it to endanger one individual, just one individual. We do not want to do that. So, Mr. Chairman, I actually have an amendment to strike the DV thing from the entire bill. We can go back, not go back, we can just stick with the felony component of it. I think that's very straightforward. I think people understand that. In the state of Wyoming right now, the numbers I received through our intern program, there's 3,400 Wyoming citizens who've had their voting rights restored through the current system we have, that at some point, based on this bill, depending on the length of their sentence and the time that's passed since they had their voting rights, would be eligible to have them, and they've not committed another crime to otherwise, impede their rights, they would be eligible. Now, I'm going to agree with what I'm going to suspect what the director said. Now, if we say they're eligible to receive all the rest of their rights, you might get a flood of saying, hey, folks, I didn't care that much about voting, but I do now. Because I want to retain the rest of my rights. I want to restore the rest of my rights. So I don't think I think there's still a lot of value in continuing the discussion about the felony. And let's be clear, if they've had their votes restored and haven't subsequently lost them, they made their one mistake, they paid their dues, and we can say, you know what, that's what we believe in, restorative justice. Come back, be a part of a productive part of hopefully a very productive society. So, Mr. Chairman, I don't know where you want to go from there. I do have an amendment that pulls the DV out of the original bill. I had two amendments, as you know, just to try to adjust DV into the bill. So there's your sign, right? There's your sign, the complexities. And Mr. Chairman, I truly learned, I wish Senator Case was here, I've truly been learning about the DV thing in the last 2 months, and it just keeps getting more. I want to continue to talk about it, but it's probably more ripe for an interim topic, for a longer discussion, understand all the complexities of it. And if you felt like the felony component, fit into that category too, I'd be respectful of that, but I do think we can move forward with the felony, because that road, Mr. Chairman, by what other states have done, is plowed ground. We have example out there. And if there's still nuances that we need to adjust, we approach that and and anyway, set aside the bigger lift. Mr. Chairman, as you know, and Chairman Case, we have a bill in another committee that we're looking at, and the more we learn this, and it's getting bigger and bigger. Is there a piece out of this bill we can salvage, just like is there a piece out of that piece of legislation that is worthy of coming forward, and we should continue? I hope you'll find that this potential approach, my suggestion would be to pull the DV out and then work the felony side, and then we go from there and see what the body would so choose, see what you would choose, and then go from there. Thank you, Mr. Chairman.
Thank you. Very well stated, and really appreciate all your work on this. This DV piece, I've spent the last 4 or 5 years working with some of the folks in that area of the world, and it's been rewarding and frustrating and difficult. It's a really deep pool of water when you get into domestic violence issues. It's so important to get it right, and so many things to consider. So I'm inclined, Senator, to go with where you are. It's funny, when you were visiting with us about that, I was thinking about that bill that we have in the other committee, and boy, did we have a lift over there. You just sometimes run into situations during the session where committee, you discover that you probably don't have time to get it all put together. And especially in this part of our statutes, we need to make sure we get it right. And that's going to take enough time that we may not be able to do it. So I would be interested, Senator, in your amendment that would probably take it back to just the felony. Committee, any thoughts on that? Is there anyone who thinks we'd go the other way? Or Senator, go ahead.
No, Mr. Chairman, I agree fully with you. I think the right way to do this is a little bit slower and make sure we get everything covered on the first part, and then through the interim we can address the domestic violence issues. I think that's prudent.
Senator Schuler.
Thank you, Mr. Chairman. Ditto. I've been struggling with some of the things with the domestic violence from the get-go. So I appreciate the bringer of the bill thinking that through and coming up with a thoughtful idea to just work on the felonies and leave the domestic violence for another time.
So, Senator, I think that's the direction we'll go. And if you would like to hand out your thoughts on an amendment, we'll take that under advisement. I want to get back to hearing from anyone in the room or someone online if they have a differing opinion or any other thoughts of what direction this might go. I do want to recognize, Ms. Muir, all the work that you put in on that domestic violence piece of this bill. It's still going to be valuable. I'm just inclined to spend a little more time with it and maybe take it into an interim. We're running into, just so everyone knows, we're running into some resistance getting a bill out on the floor on the strangulation piece, for example. That's another bill for our consideration that we drafted up, and that one probably isn't going to make it. So we have some issues in the domestic violence arena that I think we can take to an interim and do some better work on. So thank you for that, Senator. I think we'll go that direction. But in the meantime, I would, Director, I would sure invite you up to get any thoughts you have about that direction that we're considering. There are two pretty distinct pieces of this bill, and we're thinking about one of them. Hope that makes sense.
Mr. Chairman, Senate Judiciary members, I'm Dan Shannon with the Department of Corrections. To my left is Kayla Opedal, Deputy Administrator of Programming. I just have several thoughts. I appreciate that it's separated into two different separate issues. And my process behind that is, as I mentioned previously, the Department of Corrections clearly believes that for those individuals who have complied and have changed their life around, the restoration of certain rights does change and makes our community safer across our state. So the data is pretty clear on that. With that being said, as we look forward, the Department of Corrections was flattered that we would be considered to be a part of the table to discuss the domestic violence part, but I also believe that our portion would be subjective, and that the rules could change with directors in the future, and this would be, and to me, I think that's very thin ice, and I think we should be cautious about that. So the separation out, I strongly want to work with the interim committee if possible in the future, because as I mentioned earlier, we do believe certain restorations of rights is very positive and keeps our community safer. Regarding Senator Barlow's comments about the variation between the courts and corrections and the supervision thereof, that kind of clouds it a little bit. I'm sure the courts have a few things to say as well as corrections. And so I think we can iron that out in the future and maybe come up with a better process. We will continue to support, as we do, for the restoration of voting rights. And if additional rights as far as elected jurors, things of that nature comes about, we're in full support of that, Mr. Chairman. Kayla, do you have anything?
Anything, Kayla, you'd like to add this morning?
Thank you, Mr. Chairman.
Madam Deputy, go ahead.
I just wanted to add that in our fiscal note, I believe you all have a copy of it. We had identified subsection F, and Senator Barlow alluded to it. We anticipate we'll still see an increase of applications and needing that full-time position. We currently have an average of about 6 applicants that we receive a month for the voting right restoration for those in the past. And so around election time, we get a significant increase, and we do have staff that are able to manage that workload. But, citizens are going to see this as an opportunity to increase their rights across the board. So we can imagine and anticipate a pretty big increase, but we don't have exact numbers on that. But so that fiscal note, even though the domestic violence piece was removed, would still kind of stand true as far as what the department needs.
So do you anticipate that being a bump and then leveling off? I'm just wondering if we could suggest to the Appropriations Committee, we might be able to get an AWAC position easier than a full-time ongoing, you know how all that goes.
Okay.
So Chairman Landon, with the way that the statute is written, it's a 5-year wait period for all other rights and an application. So I don't know about leveling off, because currently restoration of voting rights is automatic upon discharge. So we'll restore their voting rights like we do now upon discharge, and then 5 years goes by, and then the citizen can apply. So ideally, I don't know if it'll level off, because they have to apply, if that makes sense.
Yeah, thank you for that.
Yeah.
Any questions for corrections this morning? Appreciate you guys. Go ahead, Director.
Mr. Chairman, if I just may make one comment. When the initial restoration of voting rights took place, our records, our electronic records go back to 2010, and our manual records go back to into 20s and 30s. But with that being said, from 2010 to 2018, it took 2 individuals. It took us 18 months to go through that period of time. We have to track these folks down. So we have to do backgrounds. It's quite a bit. We release in excess of 600 individuals per year. So if we went back to 2017 with the 5-year release to where our records were kept, I think we would have an onslaught of folks. But annually, we have potential for up to 600 individuals a year requesting their rights. So I hope that helps you.
It does.
Thank you, sir.
Director. Appreciate that. Appreciate you being here in case we have another question a little bit later.
Certainly.
Thank you very much. Anyone else want to testify? Ms. Beard, you're sure welcome to share any thoughts you have this morning. correct us if we're heading in a wrong direction here, or value your thoughts on this. So thanks again for the work you've done already to prepare us to tackle this thing, whenever that happens. Go ahead.
Yeah, thank you, Chairman Landon and all the senators on this good committee. It is a tough issue, complex, and I just need to say that nothing could be more important to victims. They are your most scared citizens. So to take this out is a big deal. Sorry, geez, not enough sleep. Just a couple things, and then I'll certainly let you move on to the other topics. Some of the statistics and why this is so important is right now, there is no confiscating of weapons. It is some local law enforcement, some local sheriffs certainly take that on. Certainly when it's clear they might have other reasons to take those firearms, they do, but it's just not statewide. And too often, why domestic violence is such a deep pool, I love that analogy, is the level of fear because of the threats that victims may never tell you about. There is the threats of, I will kill you because I can. While they're cleaning their gun, they'll leave a bullet on the counter and say, if you're gone, when I come home, this bullet has your name on it. So knowing that he's got that rifle in the back of his truck that no one will take couldn't be more scary. And without doing anything, we're letting those victims still struggle with that. The federal law, the US code is clear that you can't have a firearm if you've been convicted of certain misdemeanor crimes. And that's a deep pool too, which I appreciate. Let's slow down and get that right. But there's also a part of it that says, if you get them expunged, if you get those convictions expunged, if you get them pardoned, if your jurisdiction has a way to restore gun rights, you too can be relieved under federal law. That's my understanding. And I've had a good 20 years of learning about the prohibitions, and I have to say in our world, they would usually skip over the part about restoring your gun rights. And I'm mad at them. You should tell us about that more. Because I think it is a thing that some states are starting to do, and I think Wyoming could really help lead the way in that. I support doing an interim study. In another committee, they want to do an interim study around domestic violence and custody battles. And sometimes that's even more scary to lose your children versus having a gun held to your head. But I think I provided you links to lots of statistics. Guns, the presence of guns when there's that kind of intimate partner violence, she's 5 times more likely to die. When we look at the mass shootings that have recently happened, more than half of those perpetrators, there is some link to domestic violence. It also opens the whole can of worms of how do we track who's prohibited from having the firearm and who's not? What system are we using in our background checks? That's a whole nother world that I know some of, but not enough. And putting it into state law, any survivor we talk to says, oh my God, we need that. So we need to find a way to make it happen. And I'm happy to take any questions for you this morning.
Thank you, Ms. Muir. Very well stated. Would you agree that it would be a challenge to get a bill up and ready in a week on the domestic violence?
I'm up for it. And I would say that perhaps, and I know this won't go over well with anyone in Wyoming, is let's prohibit it on a state level now. And then let's worry in the interim study on how to get those guns back. No one will be hurt, especially if we're proposing some kind of finish your sentence and then you have a 5, maybe 10-year waiting period, maybe never in some cases. But getting those gun rights back is what maybe we can slow down and be clear about. Because most survivors will tell me, oh, wait, he gets to get them back. He gets to apply to get them back. I'm like, well, it's kind of the trade-off we're looking at. What are you willing to live with? Because he will apply to get him back. We're considering taking into account not only his danger to himself, but the danger to the survivor that he hurt, and the danger to society. How do you want to weigh in to say, wow, he still threatens me weekly when I drop off the kids? I don't think he should have his gun back, but I will be blamed for him not getting his gun back. It's a challenge, it's deep, but this is the place where we have to look at those most scared citizens and how do we protect them?
Thank you, Ms. Muir. Questions? Appreciate it very much.
Thank you.
Thank you.
And still, thank you to Senator Barlow. He's carried the heavy load.
Yeah, I'm aware of that. We have worked in this area of the world several times, and yeah, it's not easy, and it is emotional. Anyone else in the room want to testify on the bill this morning? Is there anyone online, Judy, who would like to testify?
Yes, we have Tyler Lindholm who would like to testify.
Okay, Senate File 120, we would welcome Mr. Lindholm, my former co-chairman of corporations, is outside in the fresh air this morning. Mr. Lindholm, good morning. If you can hear me, would you please unmute and state your name for the record, please? We're gonna, that's okay. Keep trying, and we're gonna hang in there with you here for a minute or two. Mr. Lindholm, you're unmuted. We still can't get you, Tyler. And we'd love to hear from you this morning, so we'll hang tough here for a second and see if you can get a better connection. Former representative and I chaired corporations together for a couple of years, so it's good to see him. It's always good to see him. Yeah. So, Mr. Lindholm, we're seeing a great picture of you. You're looking sharp and lots of blue sky behind you, but we just can't hear you this morning, unfortunately. Yeah. Maybe a thumbs up or a thumbs down on what you've heard this morning, the direction we may take. Tell you what, maybe drop us an email and let us know what your testimony was going to be. I'm sorry we're not getting connected. Thank you for making that effort, Tyler. We look forward to hearing from you along the way. This bill has a ways to go, so thank you so much for trying to visit with us this morning. Sorry we couldn't connect. Okay, is there anyone else online, Judy, that wants to visit with us? Okay, well, thank you. Okay, committee, we're going to close testimony on the bill. Senator, if you'd like to come forward, you had a suggestion for an amendment that would just take us down the felony piece road and set aside for the time being what we were going to consider on the domestic violence front. So would you be willing to kind of walk us through the proposed amendment that would do that?
Thank you, Mr. Chairman. So you should have a S2303 amendment. It's a single page, which you'll thank me for because there was 3 pages in the other amendments.
Yeah, there you go.
Mr. Chairman, can you hear me now?
Well, welcome back in, Mr. Chairman. It's great to see you, and now we can hear you. So
I really apologize, Mr. Chairman. I was using my work phone, which is an iPhone, and a far inferior device compared to my Android. And so I swapped over my personal phone. I really apologize, Mr. Chairman.
Really appreciate you weighing in this morning. Mr. Lindholm, take it away. We look forward to your testimony.
Thank you, Mr. Chairman. Mr. Chairman, I apologize that I am where I am at. I'm at a stock show in Rapid City at the Black Hill Stock Show. My kids are showing, so I had to scoot and come help them. But Mr. Chairman, my name is Tyler Lindholm. I'm the state director for Americans for Prosperity, which is a grassroots bottom-up organization with some conservative libertarian type leanings. And we specifically do have a criminal justice reform provision towards our organization. And this piece of legislation, even with the DV portion taken out, much respect to Senator Barlow to try and find that fix. Completely understand that it's not there at this time. Even then, it is still an excellent piece of legislation and has the full support of Americans for Prosperity coming behind it. This is an important part of empowering those that might have had a screw up in the past. And this is an opportunity for them to regain their rights and re-enter society. We all know these folks. We've got these folks in our communities. They own businesses and they're successful, and they had a little bit of a screw up when they were growing up or they were younger. I have family members that check that box and they can't vote, which is unfortunate because at one time I was on a ballot. They can't hunt, even though they're owners of a ranch. And so I think this legislation goes to fix a lot of that. I really appreciate your time, Mr. Chairman and members, and I'll stand for any questions.
Mr. Lindholm, thank you. And you're doing a lot more important work up there in Rapid City than goes on down here, I'll tell you that. Take good care of the kids, and congratulations on all that front. Appreciate your testimony. Any questions for Mr. Lindholm? Thank you, Tyler. Always good to see you. Look forward to seeing you back down here soon.
Thank you, sir.
Okay. All righty. Thank you, ladies, for getting Mr. Lindholm in. And let's go back to Senator Barlow. Senator, take it away. We're looking at a proposed amendment that would alter the bill some, so please take it away.
Thank you, Mr. Chairman. So lines 1 through 11 are basically front page stuff, just cleaning up their citations and all that, short title and all that stuff. So I just want to take you right to the meat of what the, in the bill, what this would do. So if you'll turn to page 3, under lines 6 through 14, small c, that is deleted, and that is the DV part. If you'll recall, the discussion we had, the beginning of the discussion we had in our last meeting, there were other crimes that we were going to bring into that. And completeness is important. And I certainly, anyway, so that's that. So we're striking that section. Next page, page 4, lines 4 through 15. 4 through 15, that is also a second one. Now, this is Ms. Muir, and I want to be clear. Ms. Muir made a suggestion. Well, let's actually take their rights away for the DV and worry about restoring them later. For me, I would like to have the completeness of understanding what DV is underneath Wyoming law and understanding if any or all of them should be eligible for restoration, eligible for restoration. Because I think we may find that just like we have violent felonies and nonviolent felonies, there may be DVs, and it may be one time, it may be, anyway, there degrees isn't the right word, because domestic abuse, domestic violence is domestic violence. But it is more nuanced than just you can or you can't. And maybe I was too simple in my approach. It's far more nuanced, and I am being schooled on that as we go. So this would be a part that I would suggest that Ms. Muir said, well, let's leave this in. And I'm going to ask you respectfully to say, let's just clean out all the DV stuff. Let's clean that bucket out and let's have the whole look at it. Taking this out does not change the current state of the law. If the law is insufficient now, maybe this does something more, maybe, but it does not, but the taking out does not change this current state of the law. We may have a problem with what the current state of the law is. We can work at that too. And then if this is part of it, I think that's part of a longer and bigger discussion.
You touched on something, Senator, I think is absolutely correct, at least in my limited review of these statutes over the last 4 or 5 years. There are degrees that we may want to consider for example, repeat offenders and all, I mean, you could go through a laundry list of, there's certain kinds of domestic violence that we may decide as a Senate, we just don't tolerate all the way over to that. But yeah, so I happen to believe you're onto something, and I think that's something we're gonna have to look into as we go along during the interim, but please continue.
Yes, sir. Thank you,
Yeah.
Mr. Chairman. So again, on page 4, it'd be lines 4 through 15. Let's see, I'm gonna make sure I'm right. Page 6, be 14, which is G, 14 through the remainder of the page, and then the next page through line 16, or through 15 so the bill gets cut in half by the amendment, basically, as far as verbiage. And as we started, we knew there was two policy decisions in here. One is continuation of restoration rights for nonviolent felons. The other is both taking away the rights and potentially restoring rights for DV. I'd like to, my suggestion of this amendment is let's stick to the path we already know something about. Let's understand, let's take time to do the other one, hopefully more thoughtfully. Like I said, taking the DV out, particularly the removal of the gun rights doesn't change. Taking that out does not change the current state of law. Adding it in would change the state of law. It would give Wyoming some authority over those issues, but I would suggest we have it in the fullness of the discussion. Make sure we have those crimes properly identified. We have those nuances, and that, anyway, that's just where I would ask the committee to suggest. And then the rest of the bill, Mr. Chairman, is just cleanup stuff. The right references, change G for J and J for G and F for I and all those type of things. So, Mr. Chairman, that is the suggested amendment to remove the domestic violence from the Senate File 120. Thank you, Mr. Chairman.
Questions of the senator? Any concerns or questions over the proposed amendment, committee? Okay, appreciate you walking us through that, Senator. We're going to take up the bill. Did we move it?
I'll move the bill.
Senator Schuler moved the bill, so we could certainly work it now. Committee, do I hear a proposal from anyone on the proposed amendment by Senator Barlow?
I'd like to move the amendment as written by Senator Barlow, which is 2303, is that correct?
Okay, moved by Senator Cooper, the proposed amendment. Do you have a copy of that, Judy? I thought I saw the senator hand you one. Thank you for that, Senator. Discussion on the amendment. Senator Furphy.
I was against this bill before this amendment. This helps me to feel much more comfortable with the entire bill, Mr. Chairman.
I agree. Thank you, Senator Furphy. Anything else? All in favor of Senator Cooper's motion, please say aye.
Aye.
Any opposed, no. That amendment has passed. We're back on the bill. Senator Barlow, I want to go back to you and give you any opportunity for final thoughts.
Thank you, Mr. Chairman. So, and if you'd like, I'll just walk through the felony component of the bill, and let's do it page by page so that we're all on the same page.
I think that would
if
be
you will.
really helpful. Thank you, Senator.
We've cut down at least the considerations considerably by taking out the DV, domestic violence. And, it seems to minimize it by giving it calling it DV. So I apologize if anybody listens to this and feels like we're trying to minimize the seriousness of that very difficult, challenging, and unfortunately all too common occurrence in our community. So domestic violence is now out of the bill. So on page 2, Mr. Chairman, domestic violent felony is already in statute. And then, so that's the first section. And then you see that 68102, there's a new language on line 13. Well, that language has been added because just below on line 21, that's another reason under current Wyoming statute, if you're caught with a firearm, you can have you lose your, it's a felony. bodily injury, attempting to cause bodily injury to a law enforcement or peace officer, and you can have, if you do that, it's a means to have your firearms taken away. So I'm just trying to make a consistency between violent and the pleading guilty to violent felony or trying to harm a peace officer. So that's just trying to be consistent so that we have a consistent application. Now, this is also what Director Shannon said. We're going to might have to go back and look to see if there's some nuance in that. And if we think that is, harmful to the bill, we can strike that out if the body decides we don't want it. But for the time being, I think I'd like to be able to present it to the body as, look, I'm just trying to be consistent about where you can lose a firearm in current statute and what a violent felony is. That's the effort there, Mr. Chairman.
Well, and I'm looking at the director and long ways for this to go as we work this bill along. And I'm looking at Mr. Muir too, and everyone in the room. If this bill passes out of committee and goes upstairs, all of these bills are a work in progress. We want to get them right. So thank you, Senator. Good stuff. Keep going.
Thank you, Mr. Chairman. Bottom of page 3. This is where in Wyoming statute, we would remove their ability, their competence, it's called, to use or knowingly possess any firearm. Currently in Wyoming statute, we only take away their voting rights, their juror rights, and their rights to hold public office. It's federal law that takes the firearms. This would, and this is the premise of my approach, is we have to take it away or we have to prohibit it to be able to restore it. And maybe that's not the best way, but it seems the most clean way. That's also, of course, what Ms. Muir would like us to consider for the DV side, if that is ever brought to the table. So that's where that is. Now, there may be an argument, I want to be clear with the committee, there may be an argument, well, we don't need to do this, but if we restore the rest of their rights, then the federal government will respond. I'd rather us be telling them, but there may be that discussion. And I'm open to this discussion. I just want to get the end result, whichever way it is. Next page, Mr. Chairman, of course, majority of that page got stricken. And then the bottom of page 5 is the operation of the bill as it remains for the felony restoration. And I know Director Shannon and I have gone back and forth a little bit about, does it say what we think it says? Or do the words match the intent? And I appreciate that. But what it says, I mean, you can read the words, but you have to be eligible and have received your voting rights back to be eligible for any of the other restorations. You have to have gone through the process, whether it's the automatic process that the deputy director talked about, or it's the applicant process, that is the other way, 2010, this would actually move it up, or to more current times. You have to have gone through one of those two processes, restored your voting rights, meaning no subsequent convictions or anything else, still remain eligible, and before you could have this. And the operative of this is lines, once the person has completed the person's sentence or completed or period of parole, plus time equal to the length of their sentence or 5 years, whichever is less. So the point being here is, if your felony sentence is 3 years, you've had your voting rights restored. 3 years after your voting rights, 3 years after you're eligible for your voting rights to be restored, you're eligible for the remainder of your civil rights to be restored. If you had a 10-year sentence, I'm saying 5 years is the max. The 3 to 5 years is, we've already made the policy decision as a state to restore nonviolent voting rights. That's out there. That is also the process. We've already had the process established. It's under statute already. So this one just tags onto that and says length of sentence or 5 years, whichever is least, as long as you're not otherwise incompetent, i.e. subsequently convicted of a felony crime, or DV, quite honestly.
So, Senator, some do not apply for their voting rights, do they? I got that from the deputy director. Am I reading that correctly? Not every one of them immediately apply for their voting rights back. They might wait for a while, and
So, Mr. Chairman.
that's what you're alluding to,
Mr.
Senator,
Chairman,
is
this,
that right?
in healthcare, this is called the woodwork effect. They're in the woodwork. They're in the paneling.
Okay.
They haven't come forward and said, I want my rights back.
Okay,
They haven't come
Yeah.
forward and said, I need a new hearing aid, or I need a new, transplant because healthcare doesn't cover it. And then all of a sudden they have a new opportunity and they say, okay, now this becomes more important to me. I want to reestablish my civil rights. Here is the process.
and that's what
Voting
we
rights.
talked about.
That's what
that
I'm
it
talking about.
It could create more traffic to the
Absolutely.
deputy director's purview. People coming forward saying, this makes a bigger difference now for me to get those voting rights back.
Unquestionably, Mr. Chairman, I
Yeah.
believe so.
Okay.
3,400 people, is at least the numbers that I have that were, I believe, obtained through the Department of Corrections, have already done it. What does that mean? In the next year, they have another 3,400 instead of in 5 or 6 years, they got it in, 3 months, 6 months, whatever it might be. So I think there's a very real possibility that this will engender. Now, I have constituents, you go door to door, campaigning, and just got done with that process. I have folks that say, yeah, sorry, don't bother with me. I've committed a crime. You say, well, what kind of crime? Violent or nonviolent? Well, then you have to go through what is a violent and what a nonviolent. But anyway, there's folks out there that, I said, you can vote. Go through there's a process for this. You're a crime. And then I had one fellow says, no, I'm a murderer. I said, well, you're never going to get your voting rights back.
Yeah.
So, there's that out there. But the
I
ones
think-
that
I
aren't
think every
doing
one
it,
of us know a situation where
absolutely.
just exactly what you describe, and a friend of our family,
Well, I have a family member
bad
and
night.
neighbors, both, and I don't know my neighborhood's any different than anybody else's.
Yeah.
Screw up. I think that's what Mr. Lindholm says. We screw up once in a while.
Mhm. Yeah.
So, Mr. Chairman, that's
Keep
that
going.
purpose, and hopefully it reads clear enough. And certainly if Mr. Shannon would like it to read more clearly, I will be glad to. It goes into next page, and then, of course, the bottom of page 6 is stricken off. Almost all of 7 is stricken. And then the last on 7 and 8, it's just notification, one to the, ATF about the right to use, possess again. And this is where you get into the NICS system and all that federal database stuff. And I'm not going to be an expert on that. We have folks on the floor who understand that fairly well, and we'll do our best to try to understand the implications there. And then, of course, filing with the Secretary of State. And there's probably 2 reasons for that. One is for the voting rights, just reaffirm that that's there. Second one is for the juror rights. And actually, there's a discussion about whether we should actually notify the courts as well. And because the courts are where juror lists are generated. And then rights for holding public office, because that would be something that the Secretary of State would be. So anyway, we just wanted a central repository, and then we'll figure out who needs access to that to understand it. Thank you, Mr. Chairman.
On F and G there at the end, I think that's a good suggestion, Senator. We may want those records to go to the Judiciary branch, and I don't know when or how we do that. Something to think about. The other thing that I think would probably be more transparent is if we put a position in this bill. We can refer this bill to the Appropriations Committee and suggest that committee does it, or we can put it in now. I've been down here for a while. Which way do you think resonates the most?
Mr. Chairman, I am pleased for this committee to make the suggestion based on the fiscal note, based on what the director, the department brought forth. And I thought I had the fiscal note with me. I think it's fairly straightforward to say, to have us add a new section that says whatever the proper language is for one AWAC position. I'd make it an AWAC position for, I don't know if you can look to the director to see if he wants it for 1 year or 2 years, and then the appropriate amount of money, and I just go with the round number of $60,000 per year. if you want 1 year or 2 years, and then we revisit it in the budget. And we just need it for 1 year if we're going to start this year, because we can revisit it in next year in the budget and then build that in. And then the department would have some experience about what the workload was. So, but I'm very pleased be very thankful if the committee puts it in, and then I'll go make my case to the Appropriations Committee. Thank you, Mr. Chairman.
And if and when we do that, I'll be right behind you when the fight breaks out. So, yeah, there you go. There you go. And anyone else who likes. So, committee, I'd be inclined. What are any thoughts on that position? I would make a motion that in section 2, and we would make section 2 section 3, but section 2 would become, Judy, this is conceptual, and we'll have to work with the attorneys upstairs, but one AWAC position, probably going to take 70.
Sorry, Mr. Chairman, so the fiscal note is 57,496, and I believe that is a entire position and the materials or the support service costs. So I think if you went to $60,000 and said for personnel,
Thank you.
at-will personnel and supplies, or however you want to do it, Mr. Chairman, office. Thank
So
you.
60,000, Judy, and that reflects the total cost of personnel, support services
For 1 year, Mr. Chairman.
for 1 year. And I agree with the senator, then we take it up in the budget session coming up. So that would be my motion, committee. Any thoughts on that? Ready for question on that one? All in favor, say aye.
Aye.
Any opposed, no. That amendment has passed, Judy, and we'll work that upstairs, and I'll stay in touch with the senator on that to make sure we have it right. Any other suggested amendments, committee? Anything else on Senate File 120?
I think we've got enough.
Okay, let's go to a vote. Take roll on 120 as amended. Judy, please.
Senator Case, hold it open for Senator Case.
Yes.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are 4 ayes, and we're holding Senator Case open on the amended Senate File 120.
Okay, so Senate File 120 has passed the Judiciary Committee. Nice work, a lot of work. Senator, as we go upstairs, we'll help in any way we can. Been a good effort, and look forward to the work ahead. This will be referred to the Appropriations Committee, and I'll go with you on that one.
Okay, thank you very much, Committee,
Okay.
Mr. Chairman. Thank
Yeah,
you.
thanks for all your work, Senator. Appreciate it. Director, Deputy Director, thank you for being here. Thank you, everyone. Ms. Muir, look forward to working with you as we go along on this one. Okay. Committee, we've got a couple of bills for next week that I'm going to work in. The constitutional amendment bill sponsored by Senator Rothfuss. We'll take that up Monday morning, and I'll work with Judy on a couple other bills. We've got 3 or 4 bills in the hopper still. Judy, isn't that correct?
You have a.
Oh, thank you.
A
Let's
bill
see.
log you need
Does
to-
everybody have that in there?
No,
Oh.
I didn't put it in anybody's. It's on the left-hand side of your folder.
Thank you. Just so everyone knows what we've got.
Mr. Chairman, we're still live. You want to end the meeting?